versus RLB Contracting. Is the appellant ready to proceed?
Yes, Your Honor.
You may proceed.
Morning, Your Honor. Cody Morse on behalf of Diamond Services Corporation. May it please the Court. The first thing I'd like to address is jurisdiction. The contract that is at the root of this dispute is a contract for the charter of a dredge, a contract for the charter of barges, and a contract for the charter of at least one tug for the purpose of dredging the Houston Ship Channel, which is a navigable waterway. That is a maritime contract. It is true that that contract applies Texas law, but there's a difference between choice of law, which is optional, personal jurisdiction, which you can opt into, and subject matter jurisdiction, which you can't opt into or out of, and therefore the choice of law in the contract does not control the subject matter jurisdiction for the contract.
Is it relevant, or is it too broad a question that if there are originally maritime claims and non-maritime claims, and then the maritime claims are dismissed on an interlocutory appeal, do you lose jurisdiction, admiralty jurisdiction?
Your Honor, two responses. The first is the district court rejected Diamond's effort to make this a jury trial because it held the 9H designation was conclusive and binding and good through trial. So the district court held the only way you have a 9H designation is if you have an admiralty claim.
But let's say then it's just that claim's dismissed.
Sure. Your Honor, I think that the fact is, as long as the subject matter being appealed includes the maritime claim, then there's jurisdiction under 1292A3.
So we look at the case, not the claim.
That's exactly it, Your Honor.
And what do you have an authority for that?
I don't have a citation on that, Your Honor. I guess my strongest citation is, I cited in my brief, I believe, a Fourth Circuit case about the rule of Federal Rule of Civil Procedure 9H2. And what it provides is, 9H2 is frankly patent. If there is an admiralty claim, then the entire case is an admiralty case. And so I think the strongest authority there for that, Your Honor, is in fact just Rule 9H2 itself.
Okay.
So I think that establishes there is jurisdiction over this appeal. Which brings me to the merits. The district court held that Diamond couldn't show its damages. I think it's uncontested that Diamond was delayed. And it is reasonably patent that in the nature of this work, a delay causes damages. And we know that delay caused damages here because the U.S. Army Corps of Engineers gave the entire project $6.3 million in damages for delay. And as I take the district court's holding, what the district court wanted to see was, in effect, timesheets, delay logs, some method for Diamond to calculate, here's our standby rate for our equipment, here's the amount of delay, and then, A times B equals C. Where I think that's mistaken is twofold. The first thing is under the law, which I'll get to in a moment. The second is, I think to understand this, you have to go back to what the parties met and agreed to. In the record, it's established that Diamond met with RLB and with Harbor to address this problem. And Diamond said, pay us a downtime rate. And RLB said, no, we will compensate you, we will make you whole out of a request for equitable adjustment at the end. Now, the parties could have contracted however they so desired to address this circumstance. And frankly, the fact that I'm here today is pretty strong evidence they should have done that. But they didn't. And then
It seemed to me, just to interrupt, this is
Please.
helpful, but it seemed like the district court said there were two flaws. One is just under Texas law, when you have a contract, you can't recover quantum merit.
That's to my second point on the law, Your Honor.
Okay.
But I think that,
Well, then let's stick with factually.
sure.
You're arguing that by virtue of delay and then the $6 million award, the best indication of what you're owed is the original price ratio, 54%?
That's exactly right. Your Honor, it's as simple as this. Diamond did, by dollar, $6.50 per yard out of every $12 that the contract paid. For every cubic yard dredged,
But they say they have evidence that you had the contract, you got that full price, then you got a $950,000 more.
That's right.
And where can you point to in the record, or do you not need to show that that didn't fully compensate you?
Your Honor.
Don't you have to refute it?
Sorry?
Don't you have to refute it?
The idea that 950,000, so I think that a couple of responses, Judge. The first is this. If there were some sort of way to say, here's how we get to $950,000, then absolutely. But when $950,000 is offered without any sort of strings attached, and furthermore, where $950,000 is not calculated in any sort of material way, the contract price under Texas law, the underlying contract, is evidence of the cost of delay. And so the way that's refuted is this. Diamond was offered $950,000. Diamond said, and this is in the record and it's cited in my brief, we are perfectly happy with $950,000 if that's what is offered by the Corps for Diamond's work. And if that were the case, if the Corps said, we're taking all of this, Diamond, you get $950,000, Harbor, you get whatever it may be, and RLB, you get whatever it may be, absolutely. I wouldn't be here today. But here, what happened is the Corps said, you get $6.3 million for yourself, RLB, and for your contractors, and for your subs, and the whole ball of wax. And so evidence that Diamond is entitled to more of that is the following. Diamond was equally affected by the delay as everyone else.
Same chunk of delay, undisputed, you did most of the work.
That's exactly
and yet
right.
they get most of the money. That's your argument to that.
That's really what it comes down
in your brief, I thought you said you also, the executives for RLB and the executive, I forget the name, Boyd and what's the Maturin?
Sure.
That they both said you were owed money for work undone.
That's exactly right.
Now, just give me the record sites to support those statements.
If you'll bear with me for a moment, Your Honor.
Or you could find it for when you get back up.
Thank you.
But because you did refer to them, and
Yes.
I didn't see.
Yes, in their depositions, I'll provide those record sets if you'll give me on rebuttal. To the legal issue, it is true that if the contract covers the subject matter, there is no claim that sounds in quantum mero. That follows. And if RLB had told Diamond at this meeting, we will pay you out of a delay rate. We'll pay you whatever it may be. We'll pay you some certain. That's fine. And I wouldn't be here today. But necessarily, the request for equitable adjustment is past the contract price. The contract price is for a sum certain, for a certain amount of material dredged. All that amount was paid. The request for equitable adjustment is not that. This is RLB going to the Corps on behalf of itself, on behalf of Harbor, on behalf of Diamond, and telling.
But it is saying we need more money to the Corps for the original contract work.
That's true.
I thought the district court was pointing, is it section 4, chapter 4?
That's right, Your Honor, but the underlying contract here does not include a no damages for delay clause, or at least the district court found that it did. And I struggle with that, frankly, Your Honor, because I read this, and the closest that I can come is it provides time is of the essence. Time is of the essence means time is of the essence. Thou shalt move quickly. And that follows because RLB was facing liquidated damages within about 35 days of when Diamond began working on this multi-month job. Of course, time is of the essence. Everybody wants to get this done quickly. A no damages for delay clause must say damages, and it must say delay, or some words that mean that, and give Diamond the knowledge that if Diamond is delayed, Diamond is not entitled to damages. Now, under Texas law, there are some squishy bits around that where you can still get damages for delay despite a no damages for delay clause, depending on the wording, but we're not in that ballpark because here there is no damages for delay clause. And so this subject matter of the contract is dredging. The request for equitable adjustment is exclusively because of delay, which is not addressed or not contemplated in that contract. And it was not addressed. It was addressed, I guess.
So in remind me from your brief, your best authority for that divisibility. There is a contract, it relates to the dredging, but this delay work is not integral to that contract?
RF Ball Construction Company, which is...
RF Ball?
Yes, sir.
Okay. And it's in your brief, that's great.
That's
Okay,
right.
Go ahead.
So at the end of the day here, the other thing that getting back to your previous point, Your Honor, with regard to the testimony, if there were some formula to determine how you break down the $6.3 million, then yes, absolutely, we would follow that formula. But what we have here is testimony from Diamond, that Diamond expected to be paid the pro rata price of the contract. We also have correspondence from Diamond before RLB corresponded, settled, resolved this with the Corps, where Diamond said, we expect to be paid, I think I got the numbers wrong, frankly, and said 56 instead of 54%, but the idea is right there. We expect to be paid based on the job because we're just delayed as everybody else. That's Diamond, that's the plaintiff. We also have Harbor, Mr. Maturin testified, I don't know how to split this money. If you tell me it's $1 million, I cannot tell you how you should split that money. And then finally we have RLB, which RLB submitted an earlier REA. And when I asked Mr. Boyd how that should be divided, he said, on the percentages in the contract. And I asked Mr. Boyd, why didn't that follow through when you got the money? And he said, well, the federal acquisition regulations prohibit me from doing that. Your Honor, I have read the federal acquisition regulations in great depth. I can't find it.
Could both be true, that you were paid for your extra delay work because the $950,000 covered it, but it sure seems like they got a ratio out of the Army Corps' generosity or oversight that doesn't reflect the work alignment?
So I would say, ish, Your Honor.
Yeah.
They got an oversight, excess, whatever you want to call it. You know, when Diamond filed suit, Diamond didn't know whether this suit should be filed under, as it was filed, or quitam, because it certainly seems like the Army Corps paid a lot of money here. But the Army Corps didn't pay it to RLB. The Army Corps paid it to RLB and to RLB's contractors and subs, and got indemnity from RLB to the extent, you know, this is it for this whole thing, and your contractors and subs had better not be coming after us. And so the question is how to divide that money that was paid for the whole delay, for the whole project. Now, it is perhaps conceivable that my argument that the contract price, the contract division is not what should actually be the answer here. But that's a fact question that needs to be determined at trial if there is, in fact, that dispute. That is not something that you can rule on summary judgment.
Even if there's nothing in this record that shows that you weren't actually paid for your extra work, there's still a fact question. Right, if you haven't, when you stand up or even now, you can't point to actually any cost of your clients that wasn't reimbursed.
Your Honor, that's exactly, I think, the central issue here. Diamond asked for that. In this meeting, Diamond said, pay us a downtime rate.
Yeah, that's right.
And RLB said, no, we will compensate you out of the REA. And Diamond said, okay. And Diamond began 24-hour operations. Diamond began work. Diamond continued working diligently to complete this process. The district court is asking Diamond to go back in time and catalog its damages. That's why I think that, you know, Hill versus Shamoon and Norman is particularly apropos. Even though it involves lawyers, it's like asking a contingency agreement lawyer to go back and find out what that lawyer's hours were. But the difference here is Diamond was working per yard, not per day. So Diamond didn't catalog its delay. It's very much equivalent to a contingency agreement versus an hourly agreement. And what the Texas Supreme Court said there is you can't allow another party to be unjustly enriched despite the promise implied by law to pay for beneficial services rendered and knowingly accepted. Now, in fairness, this is delay, but that delay resulted in $6.3 million. And I think that's why that case is frankly on all fours with this case. And that's why there is at the very least a fact question as to how you calculate the damages for delay. Certainly, a day rate, a standby rate, is one way to do it. And the parties were within the right to do that, but they didn't do that here. What they did instead is they said, we will compensate you out of the REA. Diamond said, we expect to get, in correspondence, before any of this was done, a little bit more than half, because we're doing a little bit more than half of the work for the REA. And therefore, I think summary judgment against Diamond on the basis that Diamond didn't have damages was improper.
Thank you, counsel.
Thank you, Your Honor.
it please the court.
You may proceed.
Christopher Solop for Harbor Dredging, Inc. My portion of this appeal is very short. We were the subcontractor to RLB. We subcontracted to Diamond to perform the dredging work. Ultimately, we paid Diamond for all the work that was performed under the contract. There's no dispute about that. The other important point is, and I pointed out in my brief at page 10, that despite all the questions about who owes what, the one point that's very clear in this case is that Harbor doesn't owe anybody anything. Diamond has admitted that, and on page 10, I say, not only has Harbor paid Diamond for all the work performed by it under the subcontract, but Harbor is not responsible for any further payment to Diamond arising out of the.
Before your time runs out of the eventual $6 million REA, how much did you make?
We received $500,000.
That's right.
Diamond received $950,000, and I think if the court looks carefully at the record, and I think we make reference to it in the briefings, that Diamond, their vice president, Jim Follett, actually agreed that the maximum amount of extra damages or extra costs that they had on this contract was $500,000 and not the amount that they're claiming that's due from RLB. And that was in part the basis for the $950,000. In fact, there's a tape recording in the record of a telephone conversation between my client's principal, Roland Martin, and Jim Follett, where he confirmed that Diamond agreed to accept $950,000. It was only after Diamond found out that RLB had negotiated a $6 million change order with the Corps that Diamond decided that that wasn't enough. And so that's primarily, I think, the reason we're here. But again, we're kind of the middleman, the conduit. There's no doubt that we have no liability in this, and so we would ask that the court affirm the lower court's determination that we were entitled to summary judgment and dismiss us from this matter.
Thank you, counsel.
May it please the court.
You may proceed.
I'm Megan Daly on behalf of Travelers Casualty and Surety Company of America. And Travelers issued performance and payment bonds to its principal RLB under the Miller Act for a dredging project. Travelers hasn't taken a position on the jurisdictional question. However, if the court does find that it has jurisdiction, then it should affirm the district court's decision. Pursuant to the Miller Act, all second-tier subcontractors are required to provide notice of its claim. Diamond is a second-tier subcontractor because there's no contractual relationship between Diamond and RLB. As such, Diamond was required to plead notice under the Miller Act as a condition precedent to its claim. Here, the district court properly granted Travelers' motion to strike. Diamond had 3 opportunities to amend its pleading to incorporate notice as required by the Miller Act, and it failed to do so. Thereafter, in the district court's ruling on Travelers and RLB's motion to dismiss, the court ordered Diamond to amend its complaint within 14 days. Diamond failed to do so. Then the district court granted Travelers' motion to strike the late amendment that was filed procedurally deficiently, and Travelers finds that believes that the district court did not abuse its discretion in granting the motion to strike, and this court should affirm. And I yield my remaining time to RLB.
All right, thank you.
Or if there's no other questions, yeah, thank you.
All right, you may proceed.
May it please the court. My name is Cody Schneider, and I represent the appellee RLB Contracting, the prime contractor for the project for the underlying case. During my time before the court, I will argue why Diamond, the appellant in this case, did not satisfy its burden of establishing that this court has jurisdiction for this interlocutory appeal for two reasons. First, Diamond failed to timely file a notice of appeal for the November 14th, 2022 dismissal order within the unquestionably jurisdictional and mandatory 30 days under Federal Rule of Appellate Procedure 4A and 28 USC 2107. And for second reason, at the time of the summary judgment order on February 14th, 2023, as admitted by Diamond during motions with the district court, Diamond's case against RLB only concerned civil claims, and as a result, was no longer an admiralty case under Section 1292A3, and therefore could not appeal under an interlocutory appeal under Section 1292A3. But before diving into the questions, the controlling questions about jurisdiction, I think it's important to kind of set up the premises of this case and the background of this case, because it's important for the jurisdictional aspect. RLB, as I mentioned, was the prime contractor for this project. Its contract was with the Corps, and that contract with the Corps included more than just dredging the material and transporting it to the offloading site. It included actually unloading the dredge material at the offloading site, transporting it, but in addition, also transporting the material that couldn't stay at that offloading site. The scope was larger at the prime contract than it was for the subcontract and sub-subcontract. And with respect to the subcontract, that subcontract was between RLB and Harbor. It is undisputed that Diamond is not a party to the prime contract. Diamond is not a party to the subcontract. Diamond's agreement is with Harbor under the sub-subcontract. And as part of the terms of that sub-subcontract, it agreed to perform the dredging work and to transport that dredging material to the offloading site, including traversing those barges to the offloading site. That is explicitly in there.
Okay. Just because you're still on jurisdiction, I mean, that sounds like a very maritime, dredging a navigable waterway sounds like a maritime case.
If we were just talking about the sub-subcontract between Harbor and Diamond, I would have a tendency to agree with you, Your Honor. However, what Diamond's claims are, the underlying claims for its claims against RLB, the prime contractor, isn't based on the sub-subcontract. It's based on claims of quantum merit, quasi-contract.
Right.
And previously, it made allegations that RLB was somehow a contractual party to either the sub-subcontract or some type of oral modification. But the court dismissed those claims.
So the jurisdiction, this jurisdictional, not the 30-day one, but this argument does depend on there being authority that something that begins as a maritime case no longer is that. It loses the status when the maritime claims are dismissed.
Yes, Your Honor.
And the best case for that?
The best case for that, Your Honor, is several cases, actually.
Well, just the best one.
The best case for that is going to be in that situation with respect to the Stute versus Floor Drilling, Your Honor, and the actual site for that case, which was decided by the Fifth Circuit.
It's in your brief, right?
Yes, Your Honor, that is in our actual response brief. And with respect to that, once the actual, and that kind of is a twofold argument, Your Honor, for that one. That one relates to the timeliness of appealing an admiralty case. So in our admiralty claim, so you have 30 days in that court, and Stute established that once you, for an admiralty claim under Section 1292A, you have to appeal that within 30 days. With respect, because there were multiple claims asserted by Diamond, and that's the issue here, is there was multiple claims. There was the alleged breach of contract.
You're not disputing at the outset, before anything was dismissed, it was an admiralty case arising, no?
Well, Your Honor, we did dispute it. One of the things about this case is when Diamond initially requested a motion for leave to amend its complaint, which was untimely at the time with respect to the lower court's rules, we objected. And we objected specifically because Diamond was trying to assert that this fell under Rule 9H, that this was an admiralty claim. And we objected at that time. We've objected throughout the lower court that this was an
And I
admiralty.
guess you need to have a case that says that 9H doesn't apply even if it begins as an admiralty case, but claims that are admiralty are then dismissed. They're, right?
Yes, Your Honor. So the case that's on point with that is, again, the issue is once those claims are dismissed.
Yes.
And they're gone. Yes. Does the case still is it still considered an admiralty case?
Yes.
Actually, the best place to look for that is actually Rule 9H and the advisory comments for Rule 9H. Because specifically, and even a case cited by Diamond from the Ninth Circuit, because the rule itself or the commentary for Rule 9H specifically says if you have an admiralty case and there are non-admiralty claims, like a civil claims, like Diamond's quantum Merowitz claims here, you can include that on an appeal of the admiralty case.
Which is where we are.
So long, and it's very clear, so long as there's still admiralty claims. And there's not
Speaks
admiralty
of claims.
claims. It speaks of claims. To be an admiralty case, even if you have mixed in civil claims, you have to have admiralty claims to be an admiralty case. At the time of this summary judgment, Diamond's case against RLB, as admitted by Diamond, no longer had admiralty claims. They were only civil claims for quantum Merowitz and for the Miller Act claim. And Diamond is judicially estopped from trying to argue something different at this point. It has admitted that the quantum Merowitz claim was a civil claim. It wasn't an admiralty claim. Diamond has admitted that the Miller Act claims are not admiralty claims. So the court no longer had admiralty jurisdiction. And Diamond cited that, and the court can see it on the record 1792, 1839 through 44. Diamond has already admitted this. Now, Diamond claims that at some point RLB had admitted that this was always an admiralty claim. As I just said earlier, RLB has never admitted that this is an admiralty claim or case. We've objected throughout the underlying proceeding. And we've consistently done that, Your Honor, throughout the proceedings. And more so,
But all the remaining claims still do pertain to the dredging work they did on the waterway.
Your Honor,
Factually.
I respectfully disagree. Diamond's claims with respect to the Quantum Miller Act, they relate to the settlement of the RAA proceeds, not for the underlying contracts themselves. And that is a distinction with a difference in this case, because Diamond's not claiming here that it wasn't paid fully under the sub-subcontract. As a matter of fact, it's admitted that it was paid fully under the sub-subcontract. That's why it doesn't have any claims against Harbor any longer, not seeking any damages any longer for anything from Harbor. It's been paid under that sub-subcontract, which may have been a maritime contract to allow for an admiralty case. We're not arguing that that's not. What the issue is with Diamond's claims here against the case against RLB is the quantum Merowitz, which this court has held, those are common law claims. Those are controlled by state court. And more so, the Miller Act claim is unquestionably not admiralty. What that is related to is a federal question jurisdiction, which is separate and apart.
Because the essence of their claim is not that we didn't get paid for the work we did. It's just that we're entitled to more money because RLB got more money. Isn't that it?
Judge Graves, you hit the nail on the head. It's not that we didn't get paid. They did get paid. Not only did they get paid, they got paid fully and they profited. They profited nearly $1.8 million, nearly 50% profit margin. And that's not me saying that. That's not my calculations. That's Diamond's old job cost reports, which the court can find on the record at 805 through 806.
805 through 806.
Yes, Your Honor.
Saying we actually got more than the work we did.
It's job cost report. That's Diamond's job cost report. And it shows the revenue for about $3 million.
Let's just indulge their argument that you're very familiar with in the briefs and oral argument. Just how much is it fair to say your client did what percent of the work relating to the delay?
Related to the, Your Honor, to be frank, that's not something I'm aware of or that's within the record because it didn't get developed at this time and it wasn't at the summary judgment stage. It wasn't necessary to bring up at the summary judgment stage at that point either because Diamond had failed to show that it was entitled to any more monies under the REA or under the sub-subcontract.
What's wrong with their logic that we did, and it's at least there's a fact issue, we did 76% of all the work after the contract was filled? but we end up with only 16% of the REA. And therefore, that's our unjust enrichment case. Are they wrong? There's a fact dispute as to whether they did at least the majority, maybe the vast majority of the work, but it likewise is true that they end up walking away with a fraction of perhaps an Army Corps overpayment.
The issue with their argument is that their claim is based on quantum merit. I think the court was accurate saying, put the subcontract to the side. That's been satisfied. So let's just look at the quantum merit claims and see what Diamond is claiming it's been, that RLB has been unjustly enriched. And the problem with their assertion is they rely on the subcontract to establish their damage model for their quantum merit claim and the Miller Act claim.
I think they're just saying we had a ratio before, and Harbor gets 500,000, we get 950,000, so that's around 1.5. But the Army Corps gave 6 million, and so RLB is unjustly enriched because we did all the work, they got all the money. That's their argument. There's a fact issue.
Your Honor, I respectfully disagree that there's a fact issue with respect to this idea of RLB was unjustly enriched, or that Diamond somehow has a quantum merit claim to recover under. Their quantum merit claim and their basis for their damages was now that they allege this 54% ratio.
Yeah.
RLB wasn't unjustly enriched. It was following through the negotiations and settlements that it had with the Corps.
Maybe RLB just negotiated a huge amount extra, and there's a key TAM case somewhere lurking.
And Your Honor, and it was based on representations from Diamond that Diamond knew was going to be represented to RLB. Diamond, as Harbor's counsel pointed out, Mr. Ferlette, who worked for Diamond, expressly agreed that $950,000 would be acceptable. Not only that, he went to Mr. Swiber, Stephen Swiber, the executive vice president of Diamond, to confirm that was the correct amount, and both knew that Harbor would take that agreement for the $950,000 and tell RLB. RLB used that information, those representations, that agreement between Harbor and Diamond, for Diamond to accept that $950,000 to negotiate the settlement of the REA with the Corps. And an important point to point out is, Your Honor, you are correct. It's $6 million was what the settlement of the proceeds were, not 6.3. And with respect to those settlement negotiations, those settlement negotiations for the request for equitable adjustment was between the Corps and RLB. And that's because the Corps was only going to negotiate with RLB because RLB was the prime contractor in this case.
And you would contend the record supports that RLB actually did a lot of work.
Yes, Your Honor, there is evidence within the record that through testimony from Randy Boyd, the president of RLB, that says the prime contract included more than just the dredging and transporting. It included the offloading the actual material, which was adversely affected by these differing site conditions. I don't think that's disputed in this case, that RLB had to do additional work and do that work as a result of this different site condition. But the issues with Diamond's underlying claim with respect to the Miller Act, and I want to go back to this 54%, that 54% is tied to that REA, basically saying, okay, we provided for the REAs this amount of money. Well, the REA is based on the loss of efficiency, the loss of productivity. That's what an REA is based off the measured mile analysis. Under the Miller Act, Diamond is not entitled to recover for loss of efficiency, loss of productivity. It's not entitled to recover that amount. That's not a recoverable amount under the Miller Act. It can recover for delay damages, and those delay damages are based on the cost for performing that additional work. And what we've already seen as established by Diamond's own records is that it's been fully paid. Not only fully paid, but has been compensated and profited a handsome amount for that. Judge Graves hit a nail on the head again. Diamond just saw that RLB got more money than Diamond anticipated after the fact, after it agreed to it, after the representation, and then tried to change course and demand for more money, and then filed a lawsuit to do so. They accepted the $950,000. They accepted every check from Harbor, but yet they wanted more money simply because RLB negotiated that funds with the Corps. No other basis, no other legal reason under it to justify them recovering that amount. So this idea for the quantum Myra claim, and I wish this court could make that decision right now. It'd be a lot easier for RLB to make that decision, render it down and tell the district court and affirm it. You were correct about the quantum Merowith claim. They failed to present evidence of the reasonable cost that they incurred because you've recovered all that money. I would love for this court to affirm the district court's decision and say, yes, the Miller Act claim doesn't allow you to recover your alleged claims for the 54%. But unfortunately, this court doesn't have the jurisdiction to do so because of Diamond's fault for not appealing the dismissal on November 14th, 2022, timely. It lost jurisdiction to those claims if they were if they were admiralty claims. And on top of that, because there's no admiralty claims in the case against RLB, Diamond didn't have the right to appeal that decision under Section 1292A3, and it's for these reasons that RLB asked the court to dismiss the appeal for lack of jurisdiction, or alternatively, affirm the district court's dismissal order and summary judgment order, Your Honors. Thank you.
Thank you, counsel. Rebuttal.
Your Honors, briefly, the record site for RLB compensating Diamond out of the REA is at 1484 to 85 and 1385 to 86. Now,
This is Boyd and Maturin statements? Sure. Sorry, it's 1484, and what was the second sentence?
85 and 1385, Harbor's is at 1344.
1344, okay.
Now, first I want to address the $950,000. Harbor said, will you take $950,000? Diamond said, maybe. Diamond said, maybe. It depends on what the Corps is willing to give. But this is crucial. Before RLB sat down with the Corps, Diamond put in writing to RLB in unmistakable terms, we expect to get 54.16% of the job. The record site for that, the correspondence is at 1436 and 1387. And the date.
Diamond's jumping over Harvard?
Diamond, yes. Harbor does nothing. Literally, Harbor gets 50 cents out of every 12 yards to bring Diamond to the job. Literally in the contract, there is nothing else for Harbor to do. Diamond goes straight to RLB, just like Diamond in the meeting about this whole REA process talked not to Harbor, but to RLB principally. So the fact that that came before RLB sat down with the Corps is at 1440 and 1439 in the record. Now, the reason that's crucial is this, and the reason that Hill versus Shamoon is so on point is this. If the Corps would have given RLB $50 for delay, Diamond would not be here because Diamond would not have its claim for any share of the REA. Diamond instead relied on RLB to do a great job negotiating with the Corps for this money. Credit to them, they did. They did an outstanding job. How much work did RLB do in this job? They did 46% of the work, closer to 47 really, because we know that RLB got $5.50 of every cubic yard that's dredged. It's right there in the contract. Now, with my remaining time, let me circle back to jurisdiction. I don't think it's right that a quantum Merowith claim doesn't sound in admiralty when that quantum Merowith claim is for delay for the provision of a dredge, tug, barges for a dredging project. In fact, I would suggest that admiralty, which is basically the last remaining bastion of judge-made law, is where equity is typically at its strongest. And so even if the contract claim was dismissed, and even if the remaining claim that survives is a quantum Merowith claim against RLB, Texas law probably applies to that. It doesn't really matter because they land at the same place. But a claim in quantum Merowith for delay and provision of a dredge to dredge a navigable waterway is fundamentally an admiralty claim, and I'd say in re later draw on for that. It doesn't apply to quantum Merowith, but it is this court's obviously lead case in how far maritime contract jurisdiction applies. The last thing I'd note, Your Honors, is this. There is no judicial estoppel here. It is true that Diamond tried to withdraw its 9H designation. RLB told the court at length that Diamond couldn't do that because RLB has known this whole time that this has been an admiralty case. I lost, RLB won. I lost on summary judgment, RLB won on summary judgment. At the end of the day here, what we have is RLB met with Diamond and said, we will make you whole out of the REA. What does that mean? I think it means that Diamond gets the amount of its damages, which we determine by looking at testimony, by looking at every other factor, by looking at the underlying contract price. Why? Because that's what Texas law.
When you say testimony, those are the two sites you gave at the beginning.
That's right, Your Honor. When RLB asks Diamond to do more work, and Diamond does more work, and Diamond saves RLB delay damages, and Diamond gets the job done, does literally all the dredging on this dredging project, and RLB goes to negotiate with the Corps to get $6 million, not for RLB, but for the Corps, Diamond has a claim in quantum merit for that. If RLB had wanted to pay Diamond downtime, RLB could have, would have, and should have agreed with Diamond to pay Diamond for its delay on that basis. Thank you very much.
Thank you, counsel. The court will take this matter under advisement. Our next case is cause